Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients with their family law, employment law, and consumer law needs. Today's video is going to address the question of whether divorce mediation works. Many, if not all, contested divorces in Texas will go through mediation at some point. It's not a particularly cheap process, but it is cheaper than going through an actual trial. Substantially cheaper, actually. So the brief answer to the question of whether divorce mediation normally works is that yes, oftentimes mediation will result in some sort of settlement agreement, and the divorce can conclude from there. But we'll talk briefly about what mediation is, how mediation reaches that settlement agreement, and the factors that often influence whether mediation will be successful. So first, let's talk a little bit about what mediation is. So mediation is a what they call alternative dispute resolution mechanism, in which basically the two sides sit down together with a neutral mediator. They both explain their positions and what they're looking for, and the mediator works between the parties to try to reach some sort of compromise between the two parties' positions that they can both accept. Sometimes in mediation, you'll see the parties broken up and they'll go into separate rooms and the mediator will shuttle from one place to another. That's fairly common in civil litigation, but in family law, mediation often occurs within the same room with the parties sitting on the other side of the table from each other, and the mediator sitting at the head of the table working between the two parties. If you've ever seen the movie Wedding Crashers, that opening scene is a very bad example of mediation, but you can kind of get the idea of what happens in mediation, that the parties are sitting down with the neutral attorneys working through the issues. And of course, it's not supposed to have the kind of hostile back and forth that you see in that movie, but it's a fairly well-known movie, and so it's a good reference for that perspective. Through the process of mediation, the mediator will explore the different positions that the parties have, look at the strengths and weaknesses of the positions, try to find the common ground, and then build from there until the parties can reach some sort of settlement. Oftentimes in mediation, particularly in divorces and other family law situations, the mediation will end up with a settlement that neither party necessarily loves, but it's a position that is a compromise that both parties can live with, and oftentimes is better than the alternative of spending enormous sums of money to go to trial and potentially being in a situation where one party loses entirely at trial, or even worse, where neither party ends up getting what they wanted, and the two parties end up spending a ton of money, and then they're both unhappy with the result. So that in itself is a really good reason to accept a settlement in mediation that's not necessarily ideal for either side, but works and at least solves some of the underlying problems so that there's a solution going forward. Although mediation is technically a voluntary process, in Texas, it's very difficult to get to a trial without the judge ordering mediation first. Sometimes one party will ask the court to order mediation first, but oftentimes, if neither party has requested it, the judges will insist that some sort of mediation take place before a final trial can be set and actually take place. So, for that reason, I generally expect that mediation will occur in all divorces that are contested, unless the parties happen to come to an agreement on their own beforehand. So that's generally what mediation is. We've talked already a little bit about how mediation results in that compromised settlement agreement, but just to touch on some of the other factors, maybe we can crystallize some of that discussion and just talk about how a good mediation will result in that settlement agreement. There's really three things that a good mediation will accomplish in order to get to that final settlement agreement. The first is to open communication between the parties. Oftentimes in a divorce, the two parties are communicating through their attorneys. Maybe on the backside, the parties are having arguments or yelling at each other, or maybe they're not talking at all. In those situations, some of the absence of communication or the bad communication between the parties can be itself a stumbling block in reaching a conclusion, and creating a forum where the parties are able to communicate openly with each other can oftentimes be helpful to understand the issues between the parties and get them to a place where they can even think about some sort of resolution and moving on past the divorce. And second, and this really ties into it, is that the mediation may be the first time the parties actually feel like their voices are being heard by the other side. Oftentimes in divorces, the parties have been in a situation where the marriage has been unhappy or unproductive for various reasons, and communication is really broken down, and they don't necessarily know how to communicate with each other in a productive manner, or there may be a lot of emotional issues that are clouding communication about the legal issues. And so creating a forum where the two parties can spill everything out and have that conversation shaped by the mediators and the attorneys involved can often help not only open up communication, but open up the individual parties and let them feel like they're connected to the process, that all of the difficult communication in the past has been opened up and released, and they're ready to move on from it, at least a little bit. But most importantly, that they feel connected to the idea that there's a resolution. If you talk to marital counselors, one of the things that they find is a huge problem in marriages is that there's either no communication or the communication itself is poor, and resolving that communication problem can oftentimes make a relationship improve. But here, of course, we're at a situation where the parties have decided they don't want to improve the marriage, but improving or correcting some of those communication problems can help the divorce process move along and for the parties to focus on their life after the marriage. And third, a good mediator should be looking at not just what the parties are saying they want out of the divorce, but looking at the underlying needs of the parties and trying to find that compromise that addresses the underlying issues. Sometimes you get people who want to argue, for example, over certain kinds of property, and the property really isn't that important, but they know that the property has some particular connection to the other side or has some particular value, and they're trying to accomplish one thing by doing something else. Maybe they're trying to hold on to that property to make sure that they're getting fair financial value when the property is divided. But if that party doesn't really have a need for that, whatever property we're talking about, the mediator might look at other property or other financial assets that can be given up instead in that compromise to make sure that that underlying goal of financial security is accomplished without it necessarily being what the parties walked in thinking they were going to get or what they were going to ask for up front. So those are the three things that we really look for to occur within a good mediation. And of course, the need for the open communication or for the parties to feel like their voices are heard is going to be dependent upon the individual situation and how much the parties in that particular divorce have communication problems or need to air out problems that exist within the divorce process that haven't been communicated already. So if those are the goals for a good mediation, the third thing we want to talk about are the factors that get us to a good, successful mediation. And here, there are really 6 factors that I consider most important to a successful mediation. First is the willingness and desire of each party to reach a resolution. No matter how good a mediator is or how good the attorneys are on both sides, if one or both spouses don't want to mediate, if they want to have that ugly trial and air out their grievances about each other in open court, a good mediation result is not going to occur. And at that point, the parties are really wasting their time and money going through the process. And so that can be a real problem. If the parties sometimes will come in without necessarily wanting to have a resolution in mediation, but a good mediator can open up the parties and get them to a point where they are willing to reach that resolution. And that's usually a cooperative effort between the mediator and the attorneys with their parties. Second is the flexibility of the parties, particularly to reach goals rather than specific points. And this is something I touched on a couple of minutes ago, really. The desire for the parties to accomplish certain goals like financial security or protecting their relationship with their children or seeing their children on a regular basis, if the parties are focused on that and more flexible about how they get to accomplish those goals, that's going to make mediation easier and for the parties to be happy with that compromised result. The more the parties are insistent that they have very specific details locked in and that there's only one way to accomplish a goal, that's going to make it very difficult to find a good fit that that's going to accomplish what the parties need and that the parties can agree to within a compromise. And again, that's as much on the mediator to open up that flexibility between the parties as it is for the parties and their attorneys to understand that the goals are more important, at least for the most part, than specifics or trying to win points or arguments within the mediation. Third is a willingness to compromise, and that means a willingness to give up on some things in order to get what's most important to you. Everybody goes into mediation with an idea that they're going to get everything they want, and they've got a specific list of requests, but it's impossible for everybody to get everything they want because at some point there's going to be an overlap between the parties where they both want some piece of property or some time with the children or the right to do something or decide something for the children. And so the parties are going to have to figure out how to come together and accept losing on some points in order to get more important or more of something that they really want or need. The more the parties are willing to have that kind of flexibility, and I guess this is really very similar to the prior point, but the more that they're willing to be flexible about what they'll give up and what they really need to get, the easier it is to get that compromise. Whereas if somebody has drawn a line in the sand and that's it for them, and they just won't give up on any points, it's extremely difficult to reach a compromise that is in any way fair for both sides. Fourth, the quality of the mediator certainly counts. Attorneys generally have ideas about the mediators they like or the types of mediators they like. Oftentimes mediators are other attorneys who practice in the field and have some training as mediators. They tend to be good mediators, but of course, not always. Sometimes there are specific issues within a divorce like business ownership or certain other kinds of assets that have to be dealt with, or children with particular needs. Sometimes finding a mediator who has expertise in that particular issue can be helpful because they bring a certain level of credibility when they talk about how to address a compromise, or can help sort of qualify some of the positions of the parties based upon their own knowledge and experience with that issue. Fifth, the analysis of a proposed settlement versus the cost of trial and likelihood of the result in a trial can be incredibly important to a mediation. If the parties are not particularly flexible, it's often very important to point out to them that they're going to spend a lot of time and a lot of money to go to trial, and ultimately, if they're fighting over one piece of property, either that property has to be sold or one person gets it and the other person doesn't. There's no way for both people to win in that regard. So looking at the totality of the proposed settlement or compromise versus what's going to occur if you move forward in a trial can be very important to figuring out what's going to work for the parties and what can be an acceptable result. And of course, the more flexible the parties are about crafting that compromise, the less important that analysis is going to be. But oftentimes, people go into mediation not perfectly open to flexibility. And so understanding what happens if you walk away from mediation without a result can be very important to encouraging the parties to become more flexible and accept something that's better for them in the long term than trying to go to trial and rolling the dice and seeing what happens. And last, the quality of the attorneys certainly matters in mediation. As an attorney in mediation, it's my responsibility, or any attorney's responsibility in that situation, to advise clients about the merits of the other side's position, of the various compromises proposed, of that comparison of mediated settlement versus going to trial, how the attorney negotiates through the mediator with the other side, how persuasive the attorney is with the other side, getting them on board with a compromise. These can all be important factors within the settlement. If an attorney comes in and is just as hostile as their client, it's really hard to have a mediated settlement in that result, because somebody has to be flexible, or both parties have to be flexible, really, in order to reach that compromise. And if one side is being very, very aggressive about not moving and really wants to just stick with what they've got, it's almost impossible to reach a compromise. So those are the factors that I would consider. As a whole, though, we normally find that divorce mediation results in some kind of settlement. Whether the parties are happy with that settlement oftentimes boils back down to their willingness to be flexible and to put their goals ahead of trying to score points, or trying to get very specific sets of requests without giving something up in exchange. So all of those things can come together. My goal in mediation is always to get whatever is best for my client, whether that is going to trial and foregoing the mediation, or reaching a compromise that's fair and helps my client move on from the divorce. But all attorneys have their own approach to mediation and their own values and what they think is right, and every client situation is going to be different and merit different kinds of analysis about what's fair, what's right, and what's going to be best for the client. In sum, that's really my position on mediation. I do think if it's been scheduled in your case, that you should go into it optimistically about the ability to reach a compromise and move forward trying to do what's best for you and what's going to be best for your future over the long term. But that's really it for this video. I hope that information was useful. If you've got mediation coming up, I hope it makes you feel a little better about the prospects that your divorce will get wrapped up. If you're looking for more information about mediation or divorce, there's plenty of information on my website as well, and I would invite you to check that out. But I think that's it for today. We'll stop there. I want to thank you as always for listening to the video, and I'll see you next time.